how to slay the first-headed monster, disability probate. Oh my. Hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Hey folks, pull up your chair, get your pen and notebook out because today we're going to learn how to slay that first-headed beast, which is probate court. Probate court's actually a two-headed beast. Death probate, which most folks are familiar with, and disability probate, which I refer to as one of the most overlooked areas in estate planning. And unlike fine wine, sadly, we typically do not get better with age. Most folks will become disabled, incapacitated before they completely check out and go up to their cloud. And you need to have proper disability planning tools in your elder law toolbox. I refer to them as power tools. And I did an article for the local newspaper, South Shore Senior News, several years ago regarding the Big Six disability planning. I have other educational videos on this subject matter because it's very important on our YouTube channel. Check it out. But let's cover it today because today's subscriber's question sent in, hey, Patrick, what do we do? How do we plan? How do we plan for end-of-life care? End-of-life care, very sad situations. And we see it often with our clients at our Elder Law Care Center and their family members. Sadly, I saw it with my late great parents as well. So folks, let's get to it. How to plan for your end-of-life care. My strong recommendation, number one, reduce it to a writing. I call it the Big Six disability planning. And because there's been case law, and the U.S. Supreme Court case and the Shivo case stated this. The court stated, hey, people, we do not want to get involved in family conflict. So it's very important to leave clear and convincing evidence of your end-of-life wishes, of your end-of-life instructions. I refer to that as number three, the Big Six disability planning. Number two is a healthcare proxy. But healthcare proxy says, hey, you're my agent. You can make my medical decisions. Typically doesn't say what decision or what direction to go. In comes the cousin to the healthcare proxy, I refer to as advanced medical directive. Advanced medical directive or medical checklist, call it what you want. But it's a medical checklist where you're giving specific instructions to your healthcare agent on what instructions to make for you. So they're not even making the decision they believe is in your best interest. They're legally stepping into your shoes as your medical surrogate, exercising what they call substituted judgment. So it's not even their decision. They're making your decision. They're acting as your conduit, communicator. When you made that decision, when you were alive and well in the third quarter of life, now maybe late fourth quarter of life, things aren't looking good for you, sadly. You could be home on hospice, and now your loved one, spouse, or child needs to make that very difficult end-of-life decision. Folks, make it easy for them. Make it easy for them. I call it the 4 C's. Number one, first C is designed to avoid conflict with medical professionals. We're educated and trained to sustain life. Put it in writing. Thank you, doc. We appreciate that medical advice, but this is what my loved one wanted in their advanced medical directive. Also designed to avoid conflict with whom else when emotions are running high. Family will say, hey, healthcare agent, you shoulda, coulda, woulda, and family reports to us oftentimes that it creates family strife and irreparable damage to family relations. Clients, you do not want that. And number three is going to give your healthcare agent confidence to make difficult decisions in a very difficult time. Number four is going to give the whole family some degree of comfort in a very sad time when they're mourning and grieving the loss of their loved one, of their matriarch, patriarch, perhaps of the family, in a time of disability and death. Now they can all move on in life knowing that they honored and respected your wishes because they followed your written instructions, and that way the family could move on, have closure, give them certainty, so they're not questioning themselves, saying they shoulda, coulda, woulda, or they can move on without any angst, regret, or guilt. And that's really important. You owe that to your family, in my opinion, folks. Advanced medical directive. You need to put it in place with the other Big Six disability plan. Healthcare proxy, number two, cousin to the healthcare proxy, advanced medical directive. Number four, HIPAA authorization, extended for 2 years after your date of passing. Because if there's any uncertainty around your passing, could be a medical malpractice or negligence, your family has uncertainty, they need certainty, they need closure, they need to get access to those medical records. Lastly, spoon-fed directive, a new one, because facilities such as memory care units and nursing homes will manually spoon-feed folks when they're no longer eating under their own volition. My dad was in a nursing home. I used to help spoon-feed him at his request. He still had his cognitive capacity, but other folks who did not have their cognitive capacity, staff members typically are trained to spoon-feed. There was a case out of New York State that I was educated on in a class with my elder law organization, where a PhD nurse said, you elder law attorneys, You need to create those spoon-fed directives because there was a case out of New York State, retired nurse with dementia in a nursing home, had a healthcare proxy, but they still manually spoon-fed her because her healthcare proxy was silent regarding spoon feeding. Folks, also, I'm going to say number 7, if someone is truly within a year of departure, going up to your cloud, if you're home on hospice, you need to have a MOLTS, a medical order regarding life-sustaining treatment. Or the national version of that sometimes is called a POLST, P-O-L-S-T, Physician's Order Regarding Life-Sustaining Treatment. That way you put in there, do not resuscitate or resuscitate, do not hospitalize or hospitalize, do not transport to the hospital, etc., etc. Code, full code, no code. So there you have it, folks. Take all the work out of it for your family, avoid family conflict, make it easy for them in a time of mourning and grieving so they can spend their energy and their focus on celebrating and remembering you and honoring you, and do not stress them out with making difficult decisions, or worse yet, creating potential family conflict, which would put your family on the back side of the cloud, family harm. You want to be on the front side of the cloud. I call it family harmony. All right, folks, there you have it right there. How to plan for end of life. You have it right there. Hopefully you took notes. Rewind it, take notes. Read my book on Amazon, How to Avoid the Four-Headed Monster of Estate Planning and Elder Law. You'll learn more about this right here. Watch other videos as well. But most of all, take action. Put it in writing. Leave that clear and convincing evidence to make it easy for your loved ones, the 4 C's. All right, folks, God bless. Make sure you subscribe and click on that notification bell. Patrick Kelleher, Elder Law Care.